Ken for the kind words, Stephen for coming back to listen to the talk, Gary Hall for overseeing my invitation to come here to Duke, all of you for coming to hear the talk. Just finished a book on the case. It's a book that we had a lot of cooperation in terms of interviews. I'd like to thank the people who agreed to do interviews. A woman named Crystal Mangum made a false allegation of rape, probably because she was about to be involuntarily committed to a mental institution. And a prosecutor named Mike Nifong, trailing by 17 points in the polls, basically out of money, chose to exploit that allegation of rape to maximize his support from the African American community, which was the only way that he could secure his primary victory, and thus remain employed in the only law office that had ever employed him, that being the Durham District Attorney's Office. And the case was sustained for really quite personal and simple reasons. In Mangum's case, as long as the case remained alive, she was eligible to receive victims' benefits that go to real victims of crime, especially sexual assault. For Nifong, sustaining the case was really critical to avoiding any chance of disbarment. The goal seems to have been to have gotten the case to trial in the hopes that he would get a hung jury, as he may very well have if the trial had occurred in Durham. And for those of you who followed his disbarment hearing, although there were a variety of specific charges raised against Nifong, underlying the entire disbarment proceedings was this belief that he had pursued a case without probable cause, and if he had been able to get it to trial, he might have avoided that. First is that it's worth remembering that this case was not just Mike Nifong. In the last several weeks, column today in the News and Observer and the editorial page of the Herald Sun, we've seen this sort of revisionist history where it was Mike Nifong and only Mike Nifong that somehow single-handedly engaged in corrupt practices. Nifong had key allies within the criminal justice system, and unlike Nifong, who has been disgraced, most of these allies remain in place, and indeed they reappeared, some of them reappeared at his criminal contempt trial. Secondly, this was a case, even though it was tried in the courtroom, obviously, where public opinion was unusually significant, and where a coalition of Nifong enablers came together and elected to exploit the case for their own purposes, and helped sustain a case that should have collapsed many months before it did. And then thirdly, it seems to me, and it's particularly appropriate given this talk at Duke, that Nifong's decision ultimately to go public and to be so aggressive in terms of cultivating public opinion ultimately contributed to his undoing, and that there was a coalition in which both faculty members and students at Duke played a critically important role in helping to change public opinion and set the stage for the bar's actions against Nifong, beginning last December and culminating with his disbarment in June. So those are the three issues that I wanted to talk about. It revealed a fundamental and deep-seated failure of the criminal justice system in Durham that went well beyond Mike Nifong. And again, while Nifong has been discredited, there's been little, if any, willingness on the part of the city manager, on the part of the former police chief in particular, to deal with some of the legacy of misconduct in this case. There are at least 5 important these criminal justice enablers. The best known is probably the man dubbed Mr. Obfuscation in the Nifong ethics trial. This was Dr. Brian Meehan, the head of a private DNA lab, a person who could not tell the same story twice, and who usually couldn't be understood the first time he told the story. The person who entered into the intentional agreement with Nifong not to report all of the exculpatory DNA data, the revelation of which was critical to undoing the case. And the second sort of well-known of these figures was Nifong's personal investigator, Linwood Wilson. In one of these only in Durham moments, could you have a Durham district attorney's office who hired as its investigator a person who had to give up his license as a PI because of ethical complaints? And Wilson's performance in this case was a deeply disturbing one in terms of especially possible witness intimidation. to try to manufacture evidence against the falsely accused players. But while Meehan and Wilson really didn't appear in the case until after Nifong had secured indictments, there were three people within the criminal, at least three people, within the criminal justice system here in Durham that appeared in the case before indictments were secured. And indeed, without these three people, the case wouldn't have existed for Nifong to exploit. In order of appearance, the first was the sexual assault nurse, the so-called sane nurse. She was technically a nurse in training at the time she conducted the examination of Mangum, a woman named Tara Levincy. Levincy had a very unusual background. I mean, we think of people in the medical community as sort of in pursuit of facts, very well trained. Levincy was really not along those lines. She had her undergraduate degree not in anything related to science or medicine, but women's studies. She spent several years after getting her undergraduate degree working for a company that did outdoor rafting tours in Maine. She had her undergraduate degree from Maine. She then decided that she wanted to become a nurse. She got a nursing degree basically on the cheap from this place called the University of Southern Maine that allows people with undergraduate degrees to get technical or vocational degrees without spending much time in terms of. This is someone who admitted in conversations, in an interview with defense attorneys that was conducted during the case, that she had never encountered a woman who had lied about rape. She admitted that Mangum's behavior was wholly atypical with real rape victims, but she said that didn't matter. Most disturbing, she displayed a willingness to change her story, change her recollection of what Mangum told her on that night at Newcastle in radical ways throughout the case, each time seeming to conform to Nifong's new theory of the case. To take one instance, on March 14th of 2006, Levincy recorded that Mangum said her rapists were named Matt, Adam, and Brett. By January of 2007, Levincy was saying that Mangum knew all along that these were aliases, not the real names of the rapists. Defense attorney Doug Kingsbury asked her, well, you do know that the Duke police actually conducted 6 lineups under the assumption that the attackers were Matt, Adam, and Brett, and Levincy's one-word response to this information was, oh. So what you had was someone who was basically willing to abuse her authority and was critical in terms of launching this fraud. The second Nifong ally within the sort of Durham system of criminal justice was a man who became quite notorious on the Duke campus, who remains employed by the Durham Police Department, Sergeant Mark Gottlieb. In the months before the lacrosse case, Gottlieb had an unusual record. He was a supervisor in District 2, which includes Durham, which includes Duke. He had arrested 10 times as many Duke students as the other 3 District 2 supervisors combined. And his record of treatment of these Duke students, which was exposed in sort of a long article in the Chronicle last September, was really horrifying. I mean, there was this one case where he dealt with a U.S. citizen of Serbian descent. Gottlieb arrested him on a noise violation and said that he was going to try to deport him. This is behavior that in a normal circumstance would not be tolerated. As became clear only much later, there was this sort of odd relationship between the Durham police and the Duke administration, where the Duke administration seemed to have gone along with what was an official Durham Police Department policy of disproportionately punishing Duke students for alcohol and noise-related offenses for which Durham residents would receive either a citation or no punishment at all. And of course, one of the problems with treating classes of people differently on the basis solely of their group identity is that these situations are subject to abuse. And Gottlieb was the classic. He was not the person who initially dealt with Mangum. He had just been reassigned before the lacrosse case began to another beat that would take him out of dealing with Duke students, partially because of this record. But by March 16th, 2 days after the case began, he was the police officer basically in charge of running the case with Ben Hyman, a very young and very inexperienced investigator serving below him. Gottlieb had what was a pattern of seeming to manufacture evidence throughout the case. His first big scoop in the case came on March 21st. He asked St. Nurse Levincy whether there had been blunt force trauma in the attack. Levincy had not mentioned blunt force trauma in her report. Levincy, however, told Gottlieb that yes, there had been blunt force trauma, and that then became a foundation for subsequent affidavits. It also received prominent treatment in an August story in the New York Times. Levincy was asked in January, could you please define blunt force trauma, since this is not a standard medical term. Her response was Crystal Mangum said she was in pain, therefore she suffered blunt force trauma.